matter of White and Alder and another.
Good morning.
Morning, my lady. My lady, my lords, just a quick word about Mr. White. You may have noticed from the papers that he has primary progressive multiple sclerosis. He had potentially hoped to be here, but with the way things are, it would be uncomfortable and difficult, and especially in light of the video streaming, he's decided to stay at home and watch proceedings there, where he can be much more comfortable.
That's completely understandable.
Thank you, my lady. So by way of introduction, approximately 275 years ago, Lord Hardwicke gave judgment in the case of Penn versus Lord Baltimore about the Penn-Baltimore Agreement of 1732. And that case, I think the Lord Chancellor said, was worthy of a decision of a Roman Senate rather than a single judge, because it concerned the boundaries between the then provinces of Maryland, Pennsylvania, and 3 counties which formed the modern-day state of Delaware. It's important to note, first of all, that the Penn family and the Baltimore family were effectively ruling as petty kings in the name of the crown by royal charter, and so the case is not strictly about 2 landowners of rival plots, far from it. It was of deep political and public significance at the time. At the beginning of the 20th century, as we can see from the authorities bundle, Halsbury's Laws of England cited this case for the proposition that boundaries can be fixed by agreement between 2 or more adjacent owners where those boundaries have become lost or confused. That was the 1908 edition of Halsbury's Laws of England. But it was only in the early 1960s that Mr. Justice McGarry gave judgment in Nielsen and Poole and applied Penn versus Lord Baltimore, along with, coincidentally, an American case called Boyd that you have in the bundle, and a Canadian case, Lawrence, that you have in the bundle. And so it was that in the 1960s, rather than, in my submission, 1750, the concept of boundary agreement entered into the common law. And one notes the fact that Halsbury's Laws of England has some similarities with the way in which Mr. Justice McGarry gave judgment. It wasn't until, so that's 1750, the beginning of the 20th century, and the 1960s. But it seems from our authorities bundle and the researchers of counsel that it wasn't really until the beginning of this century, 21st century, that there begins to be a series of cases concerning boundary agreements. So quite a gap between Nielsen and Poole and this flurry of cases. And the facts of the present case before you begin actually in 2005, just as these cases are beginning to be decided in the higher courts. And in 2005, of course, the old stores and Willow Cottage were sold in very close proximity of time. And Mr. White, you've seen gave evidence that he purchased on the basis of the land registry plans. According to the district judge's findings, paragraph 19 of the judgment, the property information form, the seller's information form signed by Mr. Hobson and Miss Bartlett, the vendors to Mr. White, suggested that there was no dispute as of August 2005, which was several months before the agreement was found to have occurred by the district judge. He also records there's no movement of it was recorded in the information form that there was no movement of the boundary in the past 20 years. So my submission to the court is that the issue of principle in this case is, in effect, twofold. Firstly, whether agreements of this sort were ever truly, in principle, proprietary without some subsequent act or circumstance occurring to give them proprietary effect. And that's ground one, of course. Secondly, ground two relates to the issue that the Land Registry has noted in its guidance, and that is whether it can be right, whether for a purchaser who is entirely unaware of such agreement, and that agreement could be express, it could be implied, or even inferred from the topography, it seems, whether it's right for someone who doesn't have knowledge of such an agreement to be bound by it. When I say knowledge of it, I mean knowledge of it prior to purchase of the property.
Isn't that just the kind of thing which standard pre-contract inquiries ought to reveal?
My lord, that's a question that leads to many other questions. If one assumes that an express agreement, which is knowingly entered into as a boundary agreement, should be on the pre-purchase information forms that are provided by a vendor, then I suppose the answer is that yes, you might expect that to be the case.
And that's the kind of agreement we're talking about here, isn't it? After all, it's in writing, it has a banner next to it, and it's unambiguous.
But of course, the facts of this case are that the agreement occurred after that information form had been provided.
Is that right? I'm sorry, I'm not sure I've got the chronology entirely straight. I meant my comment simply as a general one. I mean, you were making a general point about the possible unfairness of lack of knowledge, binding a successor entitled. But I mean, that's in principle, A, not uncommon, and B, something one might expect pre-contract inquiries to.
Yes, my lord. Then there's the difficulty of implied agreements.
Well, there could be, but we're not in that case here.
In my submission, there has to be one straightforward principle that applies to all of these types of agreements. And perhaps in the Joyce case, in the Stevenson case, this court had granted permission to the appellant on the grounds that there could be useful clarification of implied agreements. But when the case came on, counsel for the appellant expressly disavowed any attempt to clarify the law in that regard. But on ground one, I do submit to the court there has to be the common law should be straightforward in the sense there has to be one rule that applies to both express and implied agreements, if indeed implied agreements can really commonly survive unless someone acknowledges that there is such an agreement before they part with the property. If I'm wrong about all of that on ground one, if I'm wrong about the fact that something further has to happen to make an agreement proprietary, and that could be, for example, adverse possession, estoppel, a conveyance, or for instance, an application to register a determined boundary at Land Registry. So all of those things would make a boundary agreement proprietary in its nature rather than a contract between the two parties. If I'm wrong about that, then under ground two, in any case, as I say, I make the submission that the common law should not permit such an agreement to be binding on an innocent purchaser who knows nothing of it. And Mr. White's evidence in this case makes the unfairness of that position very clear. Of course, he had bought the property in 2005, and it wasn't even until 2016 that, more than a decade after purchase, with a half-built extension, half-built building, that he was informed by the respondents that there was, in fact, a boundary agreement that had been entered into, which they had become aware of between the predecessor entitled to the respondents.
But this point about knowledge was not taken below at all, and it's new.
The point about knowledge, my lady, was appeared in the skeleton argument for the district judge, and it was taken at trial. I can take you to that. So that will be in the supplementary bundle, page 4. Paragraph 8. There was some written submissions, very brief, to Lord Justice Snowdon, who granted permission on this issue, and they appear that appears at page 2
of the supplemental bundle.
Of the supplemental bundle, yes, my lord. Just paragraph 1.
But if an argument that depends upon knowledge, you'd have expected that to be pleaded, wouldn't you?
The boundary agreement, it was never accepted that there was a boundary agreement in this case. Or a boundary agreement that was signed at a time that the two previous owners were actually still the owners.
That was the issue.
That was the issue. So it was entirely denied there was any boundary agreement actually ever been entered into prior to the exchange of the contracts for sale on both sides. And so, of course, I wasn't involved in those pleadings. But I would submit that in a situation where there's an entire denial that there's any agreement, that it's incumbent then on a claimant to make out his or her case that there is a boundary agreement, and that means fulfilling the legal requirements for such a boundary agreement. I suppose it's a type of contract, and if the pleadings simply say there was not actually ever any contract, that then leaves other issues to proof, and the legal requirements are a matter for the judge then to give the judge himself directions to make the ruling that is required in each case. But of course, if it's a matter of law, I would also submit that this is not really a matter for the pleadings. It's also a matter to be raised by counsel in legal submissions. It's more complicated here because the law is in a state of flux.
Yes, but if your case was, if there was an agreement, it's not binding on me because I didn't have knowledge of it. That would have to be pleaded as a fact, wouldn't it?
It was certainly pleaded. I don't accept that proposition in the circumstances in which it's pleaded that there was no agreement at all.
So you would say the pleading of I deny there was an agreement carries with it the implicit plea that I didn't know about it.
That there is no agreement at all that yes, it carries. Well, it's a denial. So it means that unless something is admitted, the claimant still has to prove the case.
The agreement, yes. But if he does prove the agreement, then where does that leave you if you haven't also pleaded? Well, I didn't know about it.
There is, of course, another point, and that's that the district judge had that submission made. The district judge, there was no objection taken at that time, and so the time to object to that is at trial before the judge, and to seek a ruling on that. That in turn, if that ruling was against Mr. White, then he could have applied to amend. It's obviously relevant that in his witness statement makes it abundantly clear that he considers the whole thing to be fundamentally unfair because he didn't know until 2016. So in those circumstances, the district judge would have had all the evidence anyway before him and would have to have then considered whether or not to allow an amendment, if an amendment was required, to in some easement cases, for example, where you have to show that it was without permission or without force or without secrecy, then there may not be express pleadings to each, but it still is incumbent upon the claimant to satisfy the court that those requirements are made out if there's a denial that there is an easement. But as I say, I mean, the simple point perhaps is just that it was put at trial, no objection was taken. The evidence was all there. It's not a surprise.
You say all of that, but where do we find in the district judge's judgment a consideration of knowledge? I didn't find it.
The district judge dismisses the primary case put by Mr. White. That the primary case was that Mr. Justice Murray was correct, and these sorts of agreements are not binding on successors in title. Mr. Justice Murray, of course, giving the judgment in Gibson and New, which is the last judgment of the High Court on these issues. Since he dismissed that submission on the basis that what Mr. Justice Murray had said was merely an obiter dictum, he didn't need to deal with the issue about knowledge.
I'm just going to get my mind around that. I thought, so having dismissed that argument, he's found there is an agreement and that it's binding on successors. And therefore, the knowledge, if you wanted to argue, yes, but it doesn't apply to me because I didn't have knowledge, that would have to have been dealt with.
In the district judge, I think his ruling was that this was a matter which bound successors in title full stop, and that was the state of the law.
Irrespective of knowledge.
Irrespective of knowledge, and relying on the cases that my learned friend was relying on, and because they were very clear, and that Mr. Justice McGarry's judgment was very clear that it was binding on successors full stop.
But I don't think, and I'd be grateful if you had pointed out, that the district judge says it was obiter in Gibson and New. He does say, therefore it's binding on successors in title, but there isn't an extra sentence or paragraph which says, and that's the case, whether they knew about it or not. He doesn't address that issue at all, does he?
He doesn't address that issue.
No. Okay. No. I just wondered if I'd missed it.
He doesn't directly deal with it.
That's the problem with not pleading it, isn't it? Because if it had been pleaded as a fair alternative case founded upon knowledge, you might well have said to him, well, please make some findings about knowledge in case this case goes further, which, as of course it has. And as matters stand, if you succeed on a knowledge-based argument, and we agree, if we agree with you, are entitled to take it, then the case would have to be sent back for further findings of fact to be made.
Yes, my lord, the circumstances of the trial were challenging. Obviously, when my learned friend and I attended, it became obvious that we couldn't have a trial of all issues because the case, I think, was listed only for a day. And we weren't going to be able to accommodate everything.
Yes.
And so we took a pragmatic course and decided to deal with whether the boundary agreement was, whether or not there was a binding boundary agreement, rather than dealing with the remedies and the consequences. That wasn't subject to a great luxury of time to think about how to define the issues. But the argument was put, as you can see in the skeleton, and no objection was taken to that argument at trial. In the skeleton for the first appeal to the circuit judge, I, on behalf of Mr. White, expressly acknowledged that because of the way that the district judge had dealt with certain things, that it might be necessary for further legal submission, or in fact, factual evidence. So that might be the position. Although, in fact, in this case, the evidence is unbelievably clear, is that there is no basis to suggest that Mr. White knew anything. Because the district judge has made the finding at paragraph 19, I think, that if I just turn that up. Paragraph 19 of the judgment, that the information form signed by Mr. White's predecessor in title did not mention that there was any dispute in August 2005, several months before the agreement was found. There is no evidence. So there is in fact no difficulty about it, in my submission, making a final ruling on this case. The evidence is all before you, including that finding at paragraph 19 of the district judge's judgment. So that there is literally no evidence, or no one has ever suggested that he would have known. There's no way that he would have been able to know about this agreement made between two predecessors in title when his vendor failed to tell him and signed a form saying that there was no dispute at all. And it's relevant to say that although the bundle is rather thin and skinny, perhaps, it certainly wasn't like that before the district judge, because the court had the majority of the conveyancing material. And I think the district judge mentions in his judgment about the extensive material which he's gone through. And in this context, that's really the primary evidence from which anything can be decided. So on behalf of Mr. White, I don't accept the proposition that it would need to go back for factual findings, given the findings that have been made. Although, obviously, he would prefer to win the appeal and have it sent back rather than to lose the appeal. But the aspect of knowledge is obviously related to ground 2 is related to ground 1, in that in deciding whether or not something is binding on successors in title without something more, under ground 1 I'm saying it should be as Mr. Justice McGarry identified, adverse possession, or something else like a stopple, or a determined boundary application to land registry. That, in principle, that's related to ground 2 as well, because if you're deciding the circumstances under which, as a matter of principle, something can be binding on successors in title, knowledge is just one aspect of that. And of course, the pleadings typically don't raise the points of law. Mr. White's factual case was certainly set out in the pleadings. As it is, the district judge entirely rejected that. And so we're left with this factual circumstance that Mr. White doesn't accept with respect actually occurred, which he has to accept, this is the ruling of the court, and then that throws up the legal issue about successors in title, which was argued. And then, of course, on appeal was argued before the district judge and before the circuit judge. But again, the circuit judge seems to have dealt with that in terms of a high principle that these agreements are binding on successors in title, full stop. And so didn't. He says something very briefly at the end, which, of course, I had to write to the circuit judge just to remind him that he hadn't dealt with that submission. But perhaps my lord raises a point that no one recognised, but at the time, it's certainly between the bar and the judiciary, it was proceeding on the basis that the point had been rejected full stop and there was no need to deal with the other point. So, ground 1, then, in detail. The submission of the respondents is that this court is bound by previous authority. The first case, which is relied upon in my learned friend's skeleton argument for that, is a case called Webb and Nightingale. But you'll notice that that's not in the bundle of authorities. As I understand it, that case is no longer relied upon for the proposition that you're bound by a previous decision of this court. So we can provide you with a copy of it if the court pleases, but in Mr. White's submission, it's a case about the admissibility of extrinsic evidence to a conveyance rather than a Nielsen and Poole type case. And so I'll say nothing more about it. The next case which is relied upon is Burns versus Morton. This is a case where there was a single plot of land which had been divided in two, but the conveyance to each plot contained terms that a wall or fence was a party wall and represented boundary. And that seems to have been very important to the judgment. In 1967, a little fence was erected, but Mr. Morton bought his plot 2 years later in 1979, and he erected a wall. Now, if I can ask you to turn up, if I can ask the court just to turn up that decision, which is at tab 6. And then turn to the very last page of it, please. You'll see, beginning at C on that page, it's recorded that by the time of judgment in this case, the wall in question had been there for 20 years and had been accepted by the relevant owners of the adjoining land to be the true boundary. And so the first instance judge had concluded that there was sufficient evidence to imply an agreement that the wall was the boundary with reference to the conveyance which referred to such a wall. And what was said against that and the submission that was put by Mr. Kramer on behalf of the appellant is that the mere building of a wall was in this. You can see this at the bottom of page 61, little 61 in 61 of the bundle, the overall bundle. He was saying that it was insufficient, that a wall could not move a boundary.
Where are we on that page?
Right at the bottom, my lady, beginning, Mr. Kramer, on behalf of the defendant, submits the judge was wrong to come to that finding. At the centre of Mr. Kramer's submission is the concept that a building of a wall by the defendant within the confines of his own property is not capable in law of transferring the neighbouring owner's title to a strip of land between the centre of the wall and the original boundary. So that was the submission that was being made to the court. There's nothing here in this judgment to suggest that Mr. Kramer was also submitting that boundary agreements are not binding on successors in title, or any variation of that.
I thought we were on ground one. Ground one is not the successors in title point, is it?
It's not, no. But I just note in passing that that's also not.
Yeah.
There's no variation of that argument at all. It's just simply that you moving a wall can't have that effect. The first instance, it is not recorded in this judgment, as far as I can see, that the first instance judge thought that he was applying Nielsen and Poole at all, and that this is something that seems to have arisen with greater clarity on appeal, which is why I think, if you look at the last page, Lord Justice Swinton Thomas says, just below E, accordingly, not for exactly the same reasons as the judge, the judge came to the right conclusion. If looking at these authorities, it frequently is the case that arguments about boundary agreements don't quite come out properly, that they evolve. That seems to be a theme. But the court was, I have to concede, in this case, and Burns, setting out Nielsen and Poole. But when one looks at Nielsen and Poole in the way, for example, that Mr. Justice Murray did in Gibson, he looks at the ratio of Nielsen and Poole, and specifically highlights and actually underlines himself, the learned judge, that title will be acquired by limitation over time. Where Mr. Justice McGarry says that in time title is acquired by limitation, Mr. Justice Murray adds some italics in his judgment. So in my submission, this is the correct reading of Nielsen and Poole, that where two landowners have made an agreement of a demarcating kind, something else will need to happen. And so when one looks at at Burns, when one looks at Burns, you can see that the wall had been there for some 20 years and accepted by the adjoining owners. If you take the interpretation of Nielsen that Mr. Justice Murray had in Gibson, then there's nothing particularly unusual about the result in Burns. Even applying the ratio of Nielsen strictly and literally according to the words spoken by Mr. Justice McGarry.
Just explain why that is. What's the something more in this case that would involve it finding the successor?
My Lord, the something more is the fact that the wall had been there and accepted for some 20 years at the time of the judgment, as recorded on the last page of this judgment,
yes,
B to C.
The question is, what's the legal consequence of that?
Well, it seems that would be a clear case of adverse possession, limitation. It might be explicable on other principles as well. Of course, we don't necessarily always have the details of all of the facts to enable an analysis to be made, for example, of proprietary estoppel, but that always seems to be in the mix.
And the adjoining owner there was the current owner of the property. Were they weren't the person who had made the agreement, were they? Or were they?
So this, of course, was an implied agreement from the building of a wall.
Yes, but I'm just wondering who built the wall. Was this the adjoining owner, the builder of the wall, or there at the time?
No, Mr. Morton was. Mr. Morton built the wall, but Mrs. In 1965, both plots were owned by a single owner. In December 1965, Orchard Gardens was conveyed to Mrs. Hall. That had determined the conveyance relating to the wall and fence. In 1967, the other plot was conveyed to the defendant's predecessor in title. So it's the case where it wasn't, there is a change.
No, but the wall was built in 1979, wasn't it? And so the
1979 by Mr. Morton.
The implied agreement was made in 1979 after the defendant had purchased his property. Is that right?
I've got that.
So the adjoining owner is the plaintiff, I take it. And it was their predecessor in title who was there in 79.
Yes, I think that's right. So my lord, the implied agreements from the building of the wall is obviously something that one would perhaps not expect in a information form if the property was being sold, but it is a physical feature on the ground. In this case, of course, there's no evidence to suggest that anything was done physically, because both sides moved very shortly afterwards. There is one further part of Burns I just draw your attention to, and that is also on the last page. And it's at D. As I indicated earlier, the conveyance in respect of each property refers to the wall between the properties as being a division or dividing wall. That phrase clearly, to my mind, indicates an intention that the wall should demarcate the boundaries between the properties. And were it not so, as Mr. Such rightly submitted, nobody, in particular a purchaser, would be in a position to know where the true boundary between these two properties lay. The plans are not sufficiently detailed to demarcate the boundaries with exactitude, with the result that the position of the wall situated very close to the old fence was the only way in which a purchaser would know what he was buying. In my submission, it seems that what the judge is saying there is that there's two things. There's the conveyance, there's the term of the conveyance that alerts a purchaser to the fact that the wall is the boundary. And then they can look at the land and see the wall is there. They're putting two and two together and getting the right result. But that's a case, so I just note in passing when we're looking at this case, that that's obviously a case where there is something which puts the owner on notice that there is a boundary that's entirely different from a position where you have absolutely no notice or no warning at all. So Burns has got its own very peculiar facts, and that's that are right. It's right to note that. But as I say, no one was submitting in that case that anything about successes in title. The next case is that's relied upon by my learned friend is Stevenson and Johnson. That's another case in which an implied boundary agreement was said to exist. When the case, this case concerned a fence that was erected prior to 1978, and it remained even in place at the time of the court hearing. It was only in 1993 that there was a discrepancy noted between the position of the fence and what was thought to be the boundary from the deeds. So again, you've got this is a case where you've got a fence in place for a very long time between 78 and the date of the hearing, 1993, until the discrepancy was noted. And when the case, as I mentioned to your ladyship, came on, Mr. MacDonald, representing the appellant, disavowed any attempt to try and change the law or to develop the law, even though the judge granting permission had said that that was the purpose of the permission. And you can see that in the judgment. At paragraph 40, so this is tab 7. Paragraph 40. Mr. MacDonald disclaimed any intention of inviting this court to clarify matters of law. The sole issue was whether the judge had drawn the right inference from the primary facts when he found an implied agreement between Mr. Vane and the defendants. So Mr. MacDonald was saying that it was just a rabbit fence which had been put up for the sole purpose of keeping rabbits out. And that so the appeal failed because they rejected the submission which was made. So again, this case does not address the issue of successes in title, because in terms, no submission was made to that effect. I think that's accepted that this is not a binding case by the respondents, but they pray and aid remarks which were made by the judges in it. In this case, the something more seems to be the maintenance of offence between 1978 and at least 1993, or potentially the date of the hearing. That seems again. So it seems to be again a case where something was accepted for a long time.
But your core point on these two authorities is that the question of binding on successors entitled was not raised for argument. They happen to be cases where the agreement was made between at least one party who wasn't the current owner of the land.
Yes.
Yeah, that's your main point. But there's nothing else, because it doesn't deal with that, there's also nothing else which deals with the something more point, as you put it.
There's nothing else that deals with the something more, but as a matter of... It's interesting that they are both implied agreements. And in Joyce, which was some years later, this court was saying that... not in Joyce. This court had previously said that in this case, in Stevenson, that the law on implied agreements could usefully be clarified, but it wasn't. So it seems these cases seem to proceed commonly without the full argument being put, and then resulting in decisions of this court that don't fully encompass all these points, leading to ambiguity in the law. So in my submission, there is nothing to the point that there is a binding authority in this case. Webb and Nightingale is not relied upon. Burns doesn't deal with the issue of binding on successors in title, and Stevenson was decided on the basis of whether a factual inference was drawn correctly or not alone. So that there is no support to the submission that you're bound. My next submission is that it was never the case that the principle of common law was that these agreements automatically bind successors in title, and that Mr. Justice Murray was correct in Gibson and New. And again, just to reiterate, very easy for somebody who makes an agreement to then send to the land registry a determined boundary application and have that boundary fixed. And that procedure has been available since the start of our land registration system. Of course, it's usually a general boundary, but the option is there, and parties can take it if they want. They can take proactive steps to do that. And once it's fixed, it will obviously be binding on successors entitled by operation of the statutory provisions that relate to that. So, but the question here is about what the common law was, and these boundary agreements are fundamentally agreements between two sets of people. They are a settlement agreement. They could be a settlement agreement of litigation, for example. They act in personam. If you look at even Penn versus Lord Baltimore, even the settlement of these vast boundaries, which were, as I say, not really truly just property boundaries, they were the boundaries of governmental areas where these families ruled in the name of the crown as petty kings, effectively. But if you look at Penn versus Lord Baltimore, you have, which is at tab 1, and then look at the penultimate page right at the top. The Lord Chancellor says, as to the courts not enforcing the execution of their judgment, if they could not at all, I agree, it would be in vain to make a decree, and that the court cannot enforce their own decree in rem in the present case, but that is not an objection against making a decree in cause. For the strict primary decree in this court as a court of equity is in personam. So even in that case, it's recognised that a contract between two people to settle something doesn't act in rem. contrast, I mean, I have to be careful not to confuse myself because, of course, I appeared for Mr. and Mrs. New in the Gibson case, and the submission I was making to Mr. Justice Murray was that that these agreements are binding on successors in title, and in terms the judge. The analogy that I gave in that case, which is recorded in the judgment, was if a local authority had to compulsory purchase a property and there had been a boundary agreement and they were aiming to purchase the title of a particular property, that they would be bound by they would have to go along the lines of the boundary agreement, that it was in rem. And the learned judge rejected that submission, stating that it was a false, the analogy that I put forward on behalf of my clients, that was based on a false premise. And so in this case, I submit, if you look right from the start here, in Penn versus Lord Baltimore, which Mr. Justice McGarry was relying on, of course, and no doubt probably had glanced, we imagine, at Halsbury's Laws of England. Reading this case, it is the position that it was never supposed to be in rem, it was in personam. The next case I deal very briefly with, the two foreign cases. Firstly, Boyd versus Graves, which is an American authority. In that case, a surveyor had run a line in 1793 even. It was a case involving a change of ownership. So it's noted in the article by Mr. Graham Watt, which you have in the bundle, which is very illuminating and very well researched, if I may say so, that the judge instructed the jury, as is recorded in the judgment, that if the parties had come to an agreement, but then also if that had been acquiesced in for over 20 years before the commencement of the action, then they should find that the boundary was as per the agreement. You can see that at page 15 of the bundle with a black line. That's the instruction to the jury in that American case. So they don't cite Penn versus Lord Baltimore, but there seems to be how can I put it? There seems to be a surprising similarity there between what is being said in terms of Mr. Justice McGarry's limitation title being acquired over time. It was also found in Boyd to be relevant, and you can see this on the next page, page 16 of the overall bundle, that both sides had sold the land or part of the land to third parties based on the agreement, which I would suggest reinforces the idea that there was something more going on here than just a mere agreement.
Where's that?
This was page 16 of the overall bundle, yep. And then it's all in the first paragraph, which has a black line next to it. And in particular, halfway down there, possession has been held by each, and those claiming under them, respectively, from that time to the present, and each has sold parcels of land bounding on the line AE, thus agreed on, regarding it to be an established line between them. And then effectively saying, so the oral agreement accompanied by possession for 20 years. And remembering, my lord, that these are the cases relied upon by Mr. Justice McGarry. This is informing, this is why he's saying what he's saying in that case, all those years later. But Mr. Watt observes that, I think he says that there seems to be a mix here of agreement, estoppel, and limitation. Although it's not exactly expressed like that, there is certainly something more going on than just a mere agreement. Then I come to the Canadian case, Lawrence and McDowell. Now, this is headed Supreme Court cases. I was conscious to inquire as to what exactly the status of this case is, because, of course, Canada didn't exist in 1838. I think that the clue to it is in the heading where it's been given a reference, NBKB, which I understand refers to New Brunswick King's Bench. So it's actually, I think, a New Brunswick, so I ascertained, was not part of Lower or Upper Canada. So it had its own judicial system, but it nevertheless appears in reports with this heading. It, again, doesn't refer to Penn versus Lord Baltimore. It is, again, a case where the defendant had agreed to establish a line parallel to an existing wall, which unfortunately for him was, when it was run, was found to be inconsistent with the features on the ground, which he seems rather wanted to keep. The court, again, seems to have had some emphasis on the conduct of the defendant and refers to the defendant having quitted the land, quitted the walls and fences. This is on page 21, just above, in the first paragraph, but just above the little star. The conduct of the defendant was at all events most cogent evidence against him. If he's lost his...
I can't find where you are. I'm on page 21.
Page 21.
Yes.
And then there's a little star halfway, roughly halfway.
Oh,
and it says the third objection.
Thank
if
you
you go up a little bit from there...
Conduct.
The conduct of the defendant, yes. Mm-hmm. So I've put a line next to that. He's lost his vantage ground by agreeing to quit the walls and fences which formed the limits of his former occupation and to hold new line. It's his own fault. But of course, this is not a case between about successors and title. This is about something that the something that had been agreed between them, where there was conduct issues. It seems that there's a very interesting, I'll just note in passing, in the footnote to the whole judgment, in the report, it's been recorded as a number of other cases. In particular, there's a reference to a case in Nova Scotia, Davison versus Kingsman. It says it adopted the same principle. And then there's a little quote from Chief Justice Halliburton. And that, you can see, says, each of the adjoining owners holds his respective adjoining property by his legal title, but having in good faith settled the line of division between them upon the land, neither shall afterwards be permitted to dispute it. I will not shock the ears of my black-letter brethren by declaring they are stopped from disputing it, lest I should sink under the weight of the wax that such a decision should heap upon me. So, again, it all seems to be rather mixed up with estoppel in general. It's not binding, obviously, this case. You know what the modern-day equivalent would be, throwing a laptop or something. But it seems it's rather colourfully expressed there by the judge. It seems, in my submission, it shows that there's something more that usually can be said to happen in these cases. So then finally coming to Nielsen itself and dealing with it by dealing with it through the lens of Mr. Justice McGarry, in Gibson. The case that the land in Nilsson was, of course, being sold at auction. And we can see from the authority that, from the report even, that some sales particulars were attached at auction, which had a plan which was effectively the same as the plan that had been drawn up in terms of the agreement. So anyone purchasing would have been presented with that plan coincidentally. First point is that it's relevant to note that it seems that to coin a phrase, a lady from the case that you helpfully sent to us, the best or preferred justification of Mr. Justice McGarry was the interpretation of the conveyance, and that the second way of looking at it was about this agreement. In respect of the agreement, which seems to have been by way not of implication but of an agent for the executors attending the land and moving some pegs around. You can see from the report he wasn't happy with the first position of the pegs, so they were moved again, and then they come to an agreement and plan was drawn up that ended in the auction particulars. But you can see from the report that the only submission that was being made against that was that it should be registered as a land charge. Nothing else. No extensive submissions about successors and title. If I just turn the authority up, it's at tab 5. Just to give you the references for what I've just said, page 51 of the overall bundle, the pegging out is referred to halfway down that page. The second paragraph, which has a black line to it, but the detail of the pegging out is in the, well, is it the third paragraph or the middle paragraph of that page? The fact that the plan at the auction was consistent with the agreement is shown in the final paragraph. Turning over the page, we can see in the last paragraph the judge embarks upon the analysis of Penn versus Lord Baltimore, then deals with Lawrence and McDowell, and then says, in response to the submission that was made, as you can see just underneath that little quote on page 53 of the overall bundle. There may, of course, be cases in which it's uncertain or doubtful whether a boundary agreement will convey land. Thus, the configuration of the boundary may suggest the land will be conveyed without demonstrating this beyond doubt. In such a case, I'd hold the agreement is not registrable. Clause C, 4, applies to a contract to convey and not to a contract that leaves it uncertain whether or not any land is to be conveyed. In short, in my judgment, a boundary agreement is presumed not to convey land. Presumption may be rebutted to that unless it's an agreement it's not registrable. And to that point of circumstance, no doubt or uncertainty is not to rebut the presumption. In that, my submission supports the idea that it's not proprietary. And the respondents themselves obviously correctly say these things do not operate on equitable title, equitable interest. They do not convey legal rights or interests. It's about the extent of the demise. It's not proprietary in that sense.
Well, you say it's not a conveyance. Why does that mean it's not proprietary?
So, because, my lord, in an agreement, a contract between two people to, in effect, recognise that the boundaries between their properties are in position X, is a contract just between them. It's acting in personam and not in rem. It doesn't act on the thing. It's a contract between them to recognise between them that that is the true boundary. Where it may.
Then after that, they having clarified their boundary, if one of them goes on to sell, he can only sell that which he has, and that will be determined by the agreement, will it or not?
They, in such a circumstance, if that seller registers the boundary with it at land registry.
Let's look at the simple situation. Two neighbours agree the boundary, which has otherwise been uncertain, and on the plans, it's a general boundary. They then, one of them, let's just make it easy, one of them sells on. What is it that he sells on? What is the extent of his land that he sells? Is what you're saying that the agreement is between the neighbours to the extent that they remain neighbours, and as soon as one of them changes, that agreement slips away and you are back to a general boundary? If that is the case, what is it that one of them sells when he sells it? Just so that
they can. Yes, my lady. No, it's obviously a concern, like not to create a situation where there's even more uncertainty. But there's a difference. In my submission, what the court should not do is treat boundary agreements as though they are in a vacuum, and that there are no other principles of law that will operate in the variety of different circumstances that can arise. So, for example, in this example, if two neighbours had agreed the position of a boundary, then built something to delineate that boundary.
No, let's just have a completely vanilla situation. So, two neighbours agree a boundary, nothing else happens, and relatively shortly thereafter, one of them sells on. What is it that they sell on?
They sell on what they have been, what was conveyed to them by deed from the previous owner. One must look at the deeds to see what was being sold to them, because they can only convey that which they have. This is why, and if it is going to be said that, presumably by the respondents, that courts have been applying the ratio of Nielsen and Poole, why is it then, I ask rhetorically, that in Nielsen and Poole itself, Mr. Justice McGarry says that in time, by limitation, both will acquire title? In my submission, that's the correct ratio of Nielsen and Poole. That's the principle that he's applying. He is certainly not applying a principle to say that once they make this agreement, then that operates on the property to change the limits of that property. ownership.
We'll come to that, no doubt. But just in answer to my lady's question, I think your answer is that what they sell on, is a property with an uncertain boundary, because that's the starting point for the agreement.
So, my lord, I think I can answer the question very simply in that way by saying yes, they sell on what they were transferred in the first place, but
which doesn't answer the question because the boundary is uncertain.
Well, but that can be ascertainable from the deeds, for example.
What can?
Or it might be ascertainable by other principles. So, for example, in the Canadian, was it the American case? I think it was in Lawrence, there was already an existing wall. So, and it seems a rather, the court said it was his own fault. He had agreed in that case that the boundary was going to be a line run from a parallel point. And when that line was run, it went in an unfortunate position that didn't match what the pre-existing boundary features. So in such a case, if there was an immediate sale, one would have to ask the question of what such a person was selling might be referable to a prior period of adverse possession, for example, or the deeds, or proprietary estoppel. But the problem in that there are lots of different fact scenarios that can arise between two neighbours, particularly when adding in a change of ownership is just one part of it. We've seen that there are different sorts, potentially, of agreements. For example, in Joyce, the parties thought that they weren't making, they thought they were selling the land, but the court held that it was a boundary agreement. So there's lots of different sorts of fact scenarios. But the foundational principle of our law is that you can't sell what you don't have. You have the property that was conveyed to you by your previous owner. And you go back and back and back until you have a single plot of land, and then you have the first subdivision, and then you look at the deed for the first subdivision to see what it is that person had, who then conveyed on. But in the context of neighbours, of course, if there's been a fence in place for 20 years or 40 years, then adverse possession may change the limits of the property. If following a boundary agreement, a great big wall is erected in reliance on that agreement, then quite apart from it being potentially adverse possession because you've walled off your neighbour, the proprietary estoppel may operate to change the position.
These submissions all go to your primary submission, which is there's always in these cases something else, and that they're often very complex fact situations, and those factual situations change.
Yes.
But just so that I'm absolutely sure, if one was looking at the vanilla situation of two neighbours who go out one morning into their back garden and say, from now on, we agree that the boundary is wherever it is.
Yes.
And we're not looking at necessarily at a physical feature. They just say, that's where it is.
Yes.
Then you're saying that binds only them. And of course, you're saying that in the future, that there may be adverse possession or estoppel, etc., which will engrain, let's put it that way, that agreement made in the sunshine one morning. And you're saying also that if, for example, this agreement in the back garden only occurred 6 weeks before a conveyance by one of those neighbours, that in fact it has no effect whatsoever because it was only agreed between the neighbours. That's it.
Yes, exactly right. But obviously, in practical terms, if an agreement is made and then the property is conveyed and there's some reason why that agreement is adhered to, for example, a purchaser is told, well, we made this agreement, and then that's adhered to, then it will, over time, according to Mr. Justice McGarry, each in time will acquire title to the limitation of each, to the land of each other which falls on his side of the agreed boundary.
Please, could you just give me the reference for that? Which page?
So that is page 53 of the overall bundle.
Yeah.
And it is so the whole page has got the black line, but really it's the paragraph that begins, in this case, the boundary on the conveyance.
About 10 lines up from the bottom.
Yes, my lord, thank you, yes. Where, just after where it says clause C4, a contract to demarcate and confirm is not a contract to convey. No doubt the parties cannot go back on this agreement, and each in time will acquire a title by limitation to the land of the other which falls on his side of the agreed boundary.
Well, that does depend on there being some physical boundary demarcation, doesn't it? Because if it's just a line on the ground, or even, as my lady has suggested, just an agreement expressed perhaps, it's got to be expressed in some terms which one could make certain. But adverse possession, the quality of possession won't be there probably unless you actually have a fence put up or something of that nature, in which case I completely understand. Each party will probably take that as the limits of their own property and act accordingly, which is how you might get the necessary quality of adverse possession. But if it's just a line marked out with a tape measure, perhaps, and nothing more, that's not going to be so easy.
Of course it will be, if it's just marked. If you have a scenario where you have a completely open field, and one sunny afternoon they go out and say, well, okay, it's sort of here, then the chances are that a judge will never be able, firstly, it's sort of not sufficiently certain, and a judge will never be able to say what they agreed 20 years later, based on perhaps oral recollection of a person who's now living somewhere else.
I mean, in the real world, these issues only become important when you get a dispute of some kind.
Yes.
And I mean, that's no doubt why the courts lay such emphasis on the importance of settling disputes and avoiding technicality in an area where many people won't have advisors at their shoulder when they make agreements of this nature, and it's desirable for all sorts of reasons that they should, if possible, be held to them.
Yes. Obviously, in general, these points I would respectfully agree with, in terms of that it's desirable for boundary matters to be resolved without recourse to litigation. What in practice, actually, if many property practitioners now find, is that this, and as Mr. Watt refers to in his article, is that this is actually becoming a source of litigation. Because you have different sorts, so the boundary agreement concept is deployed in numerous different ways. And it might be, for example, that there's something built and someone else says that that's on my land. And then the defense will be, well, you didn't say anything, or there were some circumstances from which it was implied or inferred that you had just consented to it. Therefore, that's a boundary agreement between us. There's no trespass, and our kitchen extension or new bungalow or whatever is not, in fact, a trespass, even though the deeds show that it might be a substantial trespass, because I've got some facts from which I can give rise to an agreement. So you've got that scenario, and then you've got another scenario where someone is relying upon an agreement made by a predecessor in title a long time ago. They may be able to find one of the predecessors in title who may be able to say that one sunny afternoon we said this, and that has a variety of, the question will be how certain is that? But it puts the person on the receiving end of such a case in a very difficult position, because the evidential the evidential position of someone who's alleging an agreement is very strong, because there's usually going to be very little or nothing that someone can do to contradict it. So it's why, in the sense that it's not as if in some of the court's other cases, parties have a very long relationship with each other. They may have told lies or been not less than reliable about X or Y. These are neighbours who might have lived there decades previous. They might have some shaky recollection of something. Or even worse, it might not be an independent witness, but one side may say, with your neighbour who lived there 20 years ago, oh, I had this understanding with her, and that's an agreement. That's a boundary agreement. Very strong position, very difficult to attack such evidence, and there are serious doubts about its, but by its very nature, there must be serious doubts about its reliability, while simultaneously, in my submission, being unfortunately, sometimes psychologically very appealing to a decision maker. Because on one hand, you've got a vast amount of conveyancing material and clever submissions about what this conveyance or deed might mean, an interpretation of it. And on the other hand, you've got someone saying, well, oh, I remember on a sunny afternoon, 20 years ago, that it was this.
Yeah, but I mean, on the line of authority as we have it, we only get into this territory if you have an agreement reached between neighbours of one of the two types described by Mr. Justice Fugari and reflected in nearly all of the subsequent cases. So, I mean, yes, there are bound to be difficult areas of fact and temptation, perhaps, to blow something trivial up into something more than it was ever really meant to be. But there's no magic bullet which will solve all boundary disputes between neighbours. The most one can do is to try to narrow down the areas of dispute.
Yes.
And on the face of it, I mean, the general thrust of the authorities so far, and since Nielsen and Poole, which after all was, when was it, 1950, over half a century ago, it's held the field. It hasn't been disapproved in any subsequent authority. On the contrary, it's been followed at really pretty much all levels which have had to consider it from time to time.
Yeah.
So it's become part of the background, which is familiar to conveyances, to those who advise clients with boundary disputes, and indeed, as I think Lady Justice Arden's point can be presumed to have been in Parliament's mind when it enacted the 1989 Act about the need for written records of transactions for the disposal of land. So it developed a life of its own, isn't it? And I mean, you're not suggesting we should throw it out altogether or anything of that nature.
No.
You're just saying we should somehow limit its impact in a way which lets successors entitled off the hook. But you might think one of the fundamental points about this doctrine is that precisely it does cover not only the parties who make it, but also those who take through them in due course. I mean, if it doesn't, what's the point? Other than accepting it between themselves on a purely in personam basis.
So obviously, overall, with ground one and ground two, I'm not looking to do huge violence to the previous authorities. That's why in my submission I've pointed out that there are, in each case, nearly every case, a factual circumstance which is consistent with the result being the same if you apply, as the courts have purported to do, Nielsen and Poole. Because the ratio of Nielsen and Poole is there in black and white, where the judge clearly explains that the underlying principle of it is that by limitation over time, each party will acquire title. That is.
I can't believe that's the full ratio, or indeed a correct statement of the ratio, because it's just a throwaway sentence. And whether you will inevitably have a situation where adverse possession can apply. I mean, that's a highly technical doctrine of its own. Whether that can apply will depend on a hugely detailed examination of the facts and of the nature of the boundary agreement itself. I mean, that's the point I was putting to you a few minutes ago. It all depends. If the boundary agreement is one to erect a fence, then of course once that fence is in place and each party treats it as the boundary, then you're in the territory of adverse possession. But it's by no means obvious that every type of Nielsen and Poole agreement is going to be of that nature. On the contrary, it can be something very informally agreed between parties, which no doubt has to have the basic ingredients of a contract. Nothing beyond that.
As I say, there's the question that my lord posed at the beginning about it being something you might expect beyond the information form when property is being purchased is obviously the cases that we've been looking at are implied agreements where that might not be the case. And so if in such a, is it really the principle of law that such agreements are binding on successors in title, even though the parties to it may not actually understand that they're making an agreement, and therefore honestly and genuinely, without any malice at all, fail to inform their purchaser that there is such an agreement. My submission is that in such a case, then if such an implied agreement occurred, then over time, assuming that the court would find that there was an implied agreement, that over time, as Mr. Justice McGarry explains, they would acquire title by adverse possession, or if they did something, if they built a fence. The majority of these cases will be where someone does something immediately after agreeing it, because usually people are coming out saying, right, where's our property? We want to build a fence, or we're going to plant some trees, we're going to do something. This is a very unusual case in Mr. White's case, because nothing is done, they all just move away.
Yeah.
So
I certainly agree with you that agreements, boundary agreements in the Nielsen and Poole sense, which are inferred from conduct, are a difficult category to rationalize, perhaps, or precisely because, as you say, the problems of proof and so on are that much harder.
Yes.
On the other hand, it may be, whatever doctrine you have, there are bound to be difficult cases, margins, and perhaps it's not accidental that the two cases which are now relied on against you, as I think, being matters where it was determined as a matter of ratio and discord, were both cases involving implied agreements. But it's a danger, however, possibly of assuming that just the cases which happen to come before the courts are going to be the difficult ones at the margins. We mustn't overlook the fact that there are lots of cases where straightforward boundary agreements have not caused any difficulties, and on the contrary, have solved, or at least have contributed to taking a lot of steam out of the many, many boundary disputes which might otherwise have been difficult, yes, even more difficult than they normally are to resolve.
And my lord, so there's 2 points arising out of what you've said. Is that of course, in the majority of these cases, which are not at the extremes, someone will do something. That is the ordinary course.
Yeah.
And in such a case, then the boundary has been will usually be there for some time after that. And it will be difficult, if not impossible, for someone to come along, a successor in title, and disturb that position, money having been spent on a fence, because the court will not allow it, even if it's just by way of proprietary estoppel. But over a very long time, then you have adverse possession. But there's surely also a limit to to evidence in terms of how long how far back you can go and seek to call somebody who can give evidence about these things. And of course, the longer that time goes on, the less reliable that evidence will get if you can find anyone at all. The worst thing of all would be to infer a boundary agreement from topography, because that just runs a coach and horses through the rest of the law of property. Why bother with adverse possession when you can just say, well, 3 years ago, someone erected a fence. But there are a variety of different principles, adverse possession, proprietary estoppel, which are interacting with each other. And in my submission, the reason in part because they are the Court of Appeal cases that we have, they're on implied boundary agreements, that's why I focused on it. But as I said at the beginning, what I'm trying to convince you of is that there should be a simple rule which applies to all of these agreements. Otherwise, it's going to get very complicated to try and chop and change between implied agreements, express agreements, or even agreements just merely inferred from topography.
And you would say your simple solution is it's contractually binding between the parties. Thereafter, it doesn't bind successors in title unless there's something else, adverse possession, proprietary estoppel, whatever.
Yes, but
that's your position.
But in practice, once made, they will usually be respected. If they're not respected, there will nearly always be, in real life, something that stops someone from going back on it. If something is done in reliance on it.
Well, as between the parties, they have an agreement. But as between a successor entitled to one of them, you're saying that the agreement itself is not binding, but it's likely that there's something on the ground which will mean that there will have been adverse possession, there will have been a proprietary estoppel.
So, for example, if I am selling my house and I'm filling in the information form, and I will say, in 1990, we agreed that the boundary would be in this possession, and we built a fence, and I paid for it. Whose fence is it? Well, I paid for it. It's my fence, and we agreed the boundary would be there. It's not going to cause difficulty, and probably if it came to a court, the court would be pretty obvious what the result would be. That's just a real life example of how it works. If, of course,
and that doesn't bind the successor in title in any way because of that. It's just that is what you're selling, and you're saying precisely how you demarcate the boundary for the purposes of the sale.
Yes, so that it's unlikely in practice, in the case of a sale, to cause difficulty. And of course, in addition to, if in that example, I sold my house and I said that we built a fence in 1990, well, maybe I could say that, and the fence lasted 10 years and I replaced it again. And I planted some trees on my side of the fence and some flowers, and I've maintained it. It's pretty obvious what the result will be if you apply what Mr. Justice McGarry says in Nielsen and Poole over time. But of course, it's more than just time, because proprietary estoppel would act immediately.
Can I take you back to this proposition about what the ratio of Nielsen and Poole is? Because if you look at the bit you're relying on, don't you have to start reading at the beginning of that paragraph? Because what Mr. Justice McGarry appears to be dealing with here is the case where there are two boundaries. One is the one on the conveyance, and the other is the one subject to the agreement, and they don't coincide. And he says in those circumstances, about 6 lines in, then the agreement would have been an agreement whereby, in fact, it was agreed that land belonging to one should thenceforward belong to the other. And he goes on to say that in that circumstance, in time, one could acquire by limitation title to the land the other side, which falls on his side of the boundary. So he's talking about actually the transfer of land between one and the other, where the boundary does not coincide with what the position formally was. He's not dealing with the case of the agreement solely to clarify something which is at the present unclear.
Although if it's unclear, my lord, how would anyone know exactly what was going to be conveyed?
No, well, you don't know anything. That's the point. You do not know you'll convey anything. Here, he's dealing with a situation where you know you will be conveying from one to the other. And in those circumstances, you could acquire title by limitation. He also
Mr. Watt in his articles, I think, is a criticism made that Mr. Justice McGarry confuses the position by saying that even where it's demarcating, there might be a contract to convey afterwards. That this is why he says even if each were entitled to demand a conveyance of the land from the other, I doubt whether the agreement would be registrable. So, in my submission, he seems to be dealing with the position where it's a demarcating contract. The first type of contract is just a simple conveyance of the land. Is where it's recognised that there is a conveyance of land. Land is being transferred, and it's clear to both parties that's the case. That's not a boundary agreement in the sense that we're concerned with. It's only contracts which demarcate. This is why he says a contract merely to demarcate and confirm is not a contract to convey. So Mr. Watt makes the point that he does then say even in a contract for demarcation, then that he alludes to the fact there might be even then a contract to convey, which is a contradiction. But in practice, of course, sometimes things are settled on the basis that there will be a conveyance, even though both sides, one side might not accept that's the true position of the boundary, but for the sake of a settlement, they may take that course. I think there is obviously in the authorities bundle the earlier case by some 5 or 6 years, I think, of Hopgood and Brown, which is the proprietary estoppel case, and that there was a builder who was a shareholder in the company. The company owned one plot. The company sold the land to the builder, and the company then, on the builder's plot that he owned, built a bungalow, and he had presented plans for the construction of that bungalow to the company building it, who also owned the adjacent plot. And when the company sold that the other plot, and Mr. Hopgood tried to build his bungalow, he found that, according to the deeds, the first bungalow had been built on the land which would be encroaching onto his land, if you look at the deeds. But he was estopped. An estoppel was applied in that case, rather than boundary agreement. But if you look at what Lord Evershed said, Master of the Rolls, if we just turn up that case very quickly, tab 9.
Yeah.
Tab
4, isn't it?
Oh,
Yes.
Oh.
I mean, it may not matter, but I think it wasn't decided as what we would nowadays call a case of proprietary estoppel. It was a more formal type of estoppel, which was found to be established on the facts, wasn't it? An estoppel by representation.
Yes.
Which was accepted by conduct.
So
it's not the kind of vaguer type of proprietary estoppel case, kind of one day all this will be yours kind of thing. It may not matter particularly, but in terms of analysis, sometimes I think it's important to recognise it is a case about estoppel in a more, well, estoppel by representation, in fact, and sometimes it might be in estoppel by convention if both parties have effectively agreed to proceed on the basis of a certain state of facts.
Yes, I think, although I would submit that it's doubtful that the result would be different.
It may not be different, and it's just proprietary estoppel has come to be a label for a rather special form of equitable doctrine, which I think is not precisely what one finds in Hopwood and Brown.
So what the Master of the Rolls says in this case is that, if I can find the reference, I'll find it. He's saying that the defendant was saying to the northern neighbour, I want to build a bungalow. I've made the plans. This is where the boundary is. I want to build it accordingly. It might be I'll take a little bit of your land or you'll take a little bit of mine. Do you assent to the boundary being so assumed and fixed? And the company said, yes. So I'd make just this point, is that on the facts of this case, is that it seems as though there was an agreement as to the boundary, and then something more happened. In this case, it was much more dramatic than the building of a wall. It was the building of a bungalow.
Yeah. So there was plenty of detriment by on the part of the representative.
Exactly, my lord. But is it, in my submission, any different to the first? Is it any different, really, to what I'm trying to persuade you of? Is that if there had been an agreement and then something else had been relied upon, then that would make it instantly binding on the successor and title if they built a wall or a big fence or something like that. But that consistent with what Mr. Justice McGarry said. That's the reason that I draw your attention to this case, even though it's not in terms of boundary agreement case. Page 35, thank you. I'm reminded of the reference to that I just read out.
Yeah, no, thank you, yes.
And if you, I want to get on to ground 2, so, but I very quickly noticed that in Joyce, the court also considered, which is a boundary agreement case, proprietary estoppel was also considered to be an explanation for the result. And that case, of course, was about the construction of a garage, which encroached onto the land. It was claimed that prior to the construction, there had been an agreement clarifying the boundary. So this is the sort of scenario that I was outlining to my lord. There's the case of Haycock.
Where's the bit in Joyce?
In Joyce.
You tell us to look out for that.
So Joyce is at tab 8. And then...
Was it para 36?
46.
36.
36, thank you, my lord. Yes. I think that the judge there says something along the lines of the facts. I mean, the facts were effectively the same. And so proprietary estoppel was another explanation for the case, for the result. But apart from Mr. Justice Murray, no other judge has emphasised the point about title being acquired by limitation. And Mr. Justice Murray, I should say, did have Haycocks. He did have textbooks which set out boundary agreements and the law on it. But no other judge has focused upon that in paragraph that I clearly keep on repeating and rely on heavily in Mr. Justice McGarry's judgment about title being acquired over time. To say, even to the extent of putting italics on it. So,
which paragraph of Gibson are we looking at?
Gibson. So it starts at paragraph 132, It's page 153 of the overall bundle. And it goes on over the next 3, 4, goes to page 157. It's all got a black line next to it.
And the italicised passage.
So the analysis of Nielsen Pool starts at paragraph 141, and the italicised passage is paragraph 142 of Mr. Justice Murray's judgment. And the rejection, I mentioned the rejection of the analogy that I put forward. That's dealt with at page 104, paragraph 147. It does not bind successors in title. Mr. Wilmshurst's example of the local authority's compulsory purchase is based on a false premise. And he sets out the submission that coincidentally I made at paragraph 135, saying it was in rem, binding on successors in title. I gave the example of the local authority if they wanted to make a compulsory purchase order. So all I'm doing really under ground one is saying that Mr. Justice Murray was correct in this case. And actually, if you look back all the way to Penn versus Lord Baltimore and really actually look at what is actually the underlying justification of legal principle, in my respectful submission, he was correct and right to reject that analogy and those submissions. In the case of Haycock, which is, of course, accepted to be on the question of boundary agreement obiter, I just merely pause to note that for many years there had been hedging erected along the boundary in that case. And I think looking at the judgment, the planting of those, I think there were two types of hedging, liandi and conifer hedges, the pivotal facts. First planted in 1992, was still there in 2007. So again, another factual scenario, which, I mean, it's not binding on this court, the parties agree that, but it's interesting to see how these cases always throw up this.
Well, it's very interesting to see how Lord Justice Collins, in his one sentence encapsulation of the thing, probably states it, I mean, very clearly, in the way which probably the instinctive reaction of many property lawyers nowadays would be to say, that must be right. Which isn't to say, of course, you're not entitled to challenge it.
Well, but there is a danger, and when I'm coming onto ground two, I want to get onto ground two, but there is a danger in stating, in my respectful submission, propositions of law which are too broad. Mm. And the danger of that is that it'll end up doing injustice in a case. And this case, in my submission, is an example where certain facts are thrown up, unusual. Both sides moved out shortly after the agreement was made. No one told my clients, and nothing was done on the ground. Unusual. But the circumstances provide a set of facts from which the common law should evolve and be clarified so as to prevent injustice and a rule of law being held to be the case, which will just produce a result that no one would think is right. And certainly, I mean, my client's submission is always on to trying to develop the law in this way or to clarify the law, is that if you asked somebody on the street, whether a certain circumstance was fair, in my submission, the circumstances that have occurred here are deeply unfair. and no one would recognise it as being fair to be told 10 years later after you've bought a property that one sunny afternoon there was a chat over a garden fence or whatever. Obviously, in this case, we have a slightly more convoluted position with how the agreement came to be made. It seems that the district judge seems to think the agreement was made sometime before the written agreement was produced, because if the written agreement itself, the creation date of that would not fit with the sale of the properties, it would result in the written agreement being actually made at a time when they weren't owners. So the district judge has obviously found that some date, I think prior to the 27th of October 2005, they had reached an agreement which is reflected in that document, merely reflected in that document. So the last case is Nathalie or Nathalie, and again, not said to be binding on you, but it's useful to note that at paragraph 8 of that, the case is at tab 11. The case was actually being put forward at trial as an oral agreement supported by part performance upon estoppel upon adverse possession. It's not clear whether the estoppel claim was pursued at trial. I'm going to say no more about that because I need to get on to ground 2. Unless there's any further points on ground 1 I can address.
No, thank you.
So I have spent a long time on ground 1, but it builds the foundation blocks for ground 2. So, and as I've alluded to, it's my submission that if it's really the common law that boundary agreements can be binding on a successor in title without knowledge, then that would surely be unfair and actually quite an extreme principle, which would be unacceptably rigid. So under this ground, even if you're against me on ground 1, I am trying to convince the court that there needs to be an alignment here, a slight change in development, shall we say, in the common law, clarification, which reflects the particular facts which have been thrown up. And the land registry in its guidance, and I think if I venture to say this may have, it was obviously noted by Lord Justice Snowden in granting permission to appeal, has said that this is not clear whether it's binding on successors without knowledge. So it's an issue of importance which you must, I would suggest, think must arise sufficiently in practice to make its way onto the land registry guidance. And as I've already said, I'm not seeking to do under this ground. Under this ground, I'm seeking to do almost no violence to the previous authorities. And it's just that this hasn't been properly worked through. And I've also already, I think, outlined that boundary agreements, what is frequently said in these cases is to recite what Mr. Justice McGarry said in Nielsen and Poole, that boundary agreements are an act of peace, that it's a victory of settlement over strife, that they are to be encouraged in the law. There are various statements that my learned friend puts, quite rightly, it selects from cases over the years where the general sentiment positivity towards the boundary agreements. But I've already pointed out, and I won't sort of labour the point, that actually in practice they can result in bitter factual disputes. That's not really surprising if one thinks about what the result of it is, in that it's an argument about whether, stripping away the legal terminology, it's an argument about whether someone agreed to give someone some of their land or not. And since the statute of frauds, I think, as Mr. Watt points out in his article, 1667, Parliament has repeatedly, even right down to the Law of Property Miscellaneous Provisions Act of 1989, Section 2.1, it's been very hostile to property being dealt with other than in writing. And if the common law is not on boundary agreements, is not suitably constrained, then it opens the floodgates to arguments which are, as it were, related to the sorts of arguments that Parliament for centuries has been trying to eliminate. And I think that I respectfully observe that seems to be the point that's raised by Mr. Watt. For example, and this is what I'm arguing for under ground 2 in my submission is very modest, extremely modest. Suppose, for example, that landowner A and landowner B make an agreement, a boundary agreement. So A and B make an agreement. If B sells to C, 10 years later, A and C have a falling out about the boundary. Now B may be dead, may be untraceable by then. So the dispute is between A and C. I think that the point that my lord raised about the information form, why is it not just put into the information form? One way of looking at it would be that it would be a fraudulent misrepresentation not to put the information about a boundary agreement that you've made into the information form. If you know that you've had an agreement with your neighbour, and nowadays the SRA approved form is so broad it encompasses nearly anything, impossible to think that you could not state that. It would be a fraudulent misrepresentation. Now, if I just to argue against myself for a moment, well, that might be something that could be said to be the answer. That anyone who's in Mr. White's position should immediately commence an action for fraud against the vendor. Even presumably that itself is full of difficulty when these agreements only come to light decades after they're made, where the people making them are not experts on the law. They don't necessarily know that this is a boundary agreement, relating to this case called Nielsen and Poole. So they might honestly not include it in that information form. So, and is it really the case that, in your judgment, if I ask rhetorically, that you want to set a rule of law up that actually encourages people to commence fraudulent misrepresentation actions? But if that's not the case, then where does that leave someone like Mr. White? And in thinking of what the rule of common law should be, I readily admit that you have to weigh up the various different factors. One let me just run through some of the factors that stand in favour of Mr. White and the proposition that he puts under ground 2. And as I've said, I think I've mentioned it before, is that it would have been, let alone, never mind applying for a determined boundary at land registry, the parties could have simply asked the land registry to note on the registered title that there was an agreement. No plan need be produced if there is a feature on the ground at the relevant time. We've agreed that the fence which has been erected is the boundary. So no expense, need great expense be incurred in creating a plan. They could, of course, and they could have entered into a determined boundary application, which would have eliminated all uncertainty, using the rules which the Land Registration Act 2003, section 117 to 123, which is in tab 24, which has been a procedure that's been available since registration of land began.
That's tab
24.
Thank you.
Do you need any further information? Say nothing more about determined boundaries. But it puts the matter beyond all doubt. They could have, and obviously they could just tell the person that they're selling the property to that there was an agreement. But even then, so you've got the people who made the agreement failed to do those 3 things. Even then, the law of adverse possession and proprietary estoppel may save them if they've failed to take appropriate action to put the buyer on notice. They built a fence, they spent some money. Frankly, anyone looking to buy a property will see that there's a big fence, and most people will assume that that is the boundary, and they'll be right. And the law is at one with people's common understanding.
Well, isn't that rather the kind of situation? Of course, the facts haven't been explored, which is one of the problems. But just on the basis of the plan, in fact, the only plan in our bundle, I think, is the one at the very end, which was attached to the agreement itself. And that indicates that there is a wall, an irregular wall, or was at the date the agreement was made, surrounding the old stores, which is the property immediately adjoining your client's property. So that was the feature on the ground, which one might naturally have supposed would be, if there was nothing else, what one might have imagined would be the boundary between the two. But we now know the parties agreed differently. They agreed that the whole of the boundary feature the whole of the wall should be treated as belonging to the old stores.
Yes.
And then we have a situation where your client began works in 2019. We don't know the details of them. We don't know what inquiries he made. We don't know if he tried to consult the neighbours or what, or whether he just presented them with a fait accompli. But either way, that wall was still in existence. And one of the complaints in the particulars of claim is that your client demolished part of that wall. So, I mean, it might be said on any view that was a rather, depending on the inquiries and preliminary steps he'd taken, that might have been a rather rash thing to do without.
So, my lord,
no problem.
It's worth reading the statement of Debbie White and Darren White, the areas and those sections which have been highlighted. That's the evidence that they gave.
Sorry, where is this evidence?
In the supplementary bundle.
Is there any, I mean, are we... I haven't looked at that because I wasn't sure whether there was any objection to it being shown to us. But,
well, it's an agreed bundle.
Okay.
So
the answer is one will here find your plans.
Well, how
it all happened.
The short version is, of course, is that which which you can read from these statements. But the short version is that they did not know anything when the property was acquired in 2005. They only found out in 2016. There was a period of some years when the planning application was opposed by the respondents, but it was never said that they were the owners of the land which the building was going to be built on. That the building was effectively half built when Mr. White also points out that there was some liaison about the exact position that it was going to be sited on with the respondents at the time. It's not a case on their evidence where they simply went out and started hacking things around or built anything without warning. And that it was only when the building was half built that Mrs. Alder told Mrs. White for the first time that there was a boundary agreement that they had with their purchasers, but with their vendors. But so it's agreed material. Both I don't want to sort of read out the statements, but what I've done is I've highlighted the relevant red parts. But in short, that's the position. But my lords recognise that the agreement is rather at odds with what one might think to be the case if you went there. That in terms of the ownership of the walls and the position of the house and the access and so on and so forth. But be that as it may, the question is whether or not it's binding on Mr. White without notice.
Don't use the word notice. Please.
Without knowledge.
Without knowledge.
So I don't want to read all that material out, but I've put red lines next to the relevant paragraphs.
And you're not saying that there are any authorities which go directly to this issue, just the points that you've made before about the fact that you say that in lots of cases there's proprietary stock, for example, and all those other factors. But there's nothing that actually impinges directly on the issue of knowledge.
No, there isn't. And so, I mean, the only sort of official type reference to it is by the Land Registry. But I can't ascertain where that has come from, other than, no doubt, very experienced lawyer at Land Registry observing that certainly might seem to be a problem with the whole thing. So, in this way, what I'm trying to convince the court of is to clarify the law so that it actually reduces the risk of future disputes.
And the knowledge is actual knowledge?
Yes, it would have to be that they actually know. I mean, of course, if you had a agreement noted on the title and the conveyancing solicitors would be looking at that material, then obviously that would be counted as knowledge. It would be attributed to the purchaser.
What is the procedure of getting a note on the title? Is it run in the formal, or is there some formal type of application you have to make? I imagine there is some sort of form you have to fill in. And you have to give some reason for putting it on the title, and perhaps they might come back and say, well, if there has been a boundary agreement, why was there not a... sorry, what I've forgotten now is the word for... why haven't you asked for a fixed boundary?
I think it might be I don't think the Land Registry would, as it were, encourage people to go down a determined boundary route.
No, and equally I would have thought they wouldn't they wouldn't want to have too many notes put on
I
the
might
title
need to check the
without there being good reason for doing so.
I know that the Land Registry do note on title boundary agreements. Sometimes at the end of horrible boundary dispute trial, the parties, a judge, to my experience, has ordered that it be noted to have, because I suppose the Land Registry is unlikely to disobey the order of the judge. But but I know that that's done sometimes as a way to save expense of a determined boundary.
Yes, and I'm sure it's often done internally by the Land Registry, just as a sort of cross-reference mechanism where they reckon something pertaining to boundary A to title A might also have some relevance to title B, and they make it. What I don't know is whether the parties themselves or the registered proprietor can apply for a note to be added. I just don't know what the procedure is.
I can check the exact provision. I think it might be a unilateral notice.
Yeah, sorry, this may be a red herring, and I.
Yes. Well, I'm helpfully reminded it might be a form AN1, which is an agreed notice, or a unilateral notice form UN1. But,
thank you.
But I can double check that. But you'll note I spent some time focusing on implied agreements, and you may wonder why it's not an implied agreement case. But I note that there is, in thinking this through, an effect on agreements which might be implied. Because those sorts of agreements are unlikely to be actually within the knowledge of the parties who made them. They may be, if they are, if it's obvious that they should, but if it's merely, it depends on the circumstances of the implication. But if those agreements, if implied boundary agreements become less prevalent, then in my submission that's no bad thing, because they are perhaps the worst excesses of boundary agreements in a way. They're agreements that no one thinks they've made, where principles of adverse possession or even proprietary estoppel would be perfectly adequate to deal with the scenario. Otherwise, you get into the circumstance where you've got implication from, say, a fence that's been there 5 years. Well, what's the point in adverse possession then? It gets to the point where it gets out of control and it becomes a cure-all, which is psychologically attractive, but in fact actually liable to do injustice and raise issues about evidence being given from a long time ago. I know in easement cases, of course, if I recall, the law, when it first started, the instructions to the jury starts out having to deal with periods of time which are far too long for anyone to really give evidence or reliable evidence about. And then the courts invented the fiction of lost modern grant. So we really is the court really saying you could have an implied agreement from, is that the right analysis from a fence that's been there for 40 years? It seems if there's a negative effect on implied agreements from the principle of law that I'm trying to convince you of, then I would submit respectfully that that's no bad thing. And bearing in mind all the other things that those landowners could do to clarify the position, and bearing in mind all the saving graces that they have, that the law will afford them to prevent an unjust result. And then obviously that adverse possession has a statutory footing as well. So we know that Parliament has intended that to be saved, and we see in the Law Commission report as well that obviously that adverse possession is thought still to, which led to the Land Registration Act of 2003, that these things have been preserved and put onto a statutory footing. proprietary estoppel or not, but expressly, I think the prevailing view is that is certainly not is not abolished in terms of boundary disputes. So in terms of the land registration system coming to the end now, it's not just, of course, the fact that you could put a note on the title. That's not. It's relevant also to observe that historic deeds and conveyances are still available from the land registry, and we're told in, I think, Alan Wibberley building by Lord Hoffman, that they are the starting point, even in the case of registered land, to look at the deeds and conveyances to see, and my lady, the point that you raised right at the outset, what am I buying? I mean, I suppose that's the reverse question, isn't it? On one hand, you can say, what am I selling? But it's actually probably, the person who's buying is probably much more concerned with the buying. So if these deeds can be inspected, requested from land registry, especially in case of ambiguity, it will certainly be the case that will be done. In practice, of course, if physical features are not clear on the ground, then that might be an alert, a red alarm bell to an alarm bell even to a conveyancing solicitor. But if somebody purchases a property based upon an uncontroversial analysis of those deeds, or what they look at on the ground as well, marry the deeds together, there's not really any ambiguity, at a stretch, some small ambiguity. Is it right that 20 years later someone can say, effectively, surprise, I made this agreement on a sunny afternoon, and there's no writing, it's just my memory, and I'm right. And there's no corroboration because everyone else is no longer around, but I can tell you I'm completely correct about this. This sort of off-the-books kind of exchange of land, if you like, that contradicts historical documents of deeds and conveyances poses a threat. But it can, the threat, I would suggest, be tamed by introducing or saying that the law is that knowledge is required. I also note that in Joyce, and Mr. Watt addresses this case in some detail, he's very critical of Lady Justice Arden's analysis, because of course Joyce was about whether Section 2.1 of the Law of Property Act 1989, miscellaneous provisions, was contravened by a boundary agreement. So it's effectively a modern day formality attack, just in the way that in Nilsson and Poole, the failure to register it as a land charge was being attacked. So there's a sort of variation on a theme, really. But what Mr. Watt points out is that if I just turn up his article, which is at tab 15, and then turn to page 200 in the page 200 of the overall bundle, under the heading Judicial Reception, Joyce and Regaley. And this is worth reading. He sets out the passage from Lady Justice Arden's judgment. And as a matter of ordinary English usage, for a contract to be one for selling or disposing of land, it must have been part of the purposes in entering into such a contract that the contract should achieve a sale or other disposition of land. The fact that the effect of the contract is the land that the interest is actually conveyed is not the acid test. Indeed, it be a surprising result of Section 2 applied merely because the effect of the contract was that an interest in land was transferred, even though the parties had no intention to make such transfer. So, because in this case, the parties actually did think that's what they were doing. They were transferring land, in which case they wouldn't fall within the, on one view, they wouldn't fall within the remit of a boundary agreement. But what Mr. Watt is saying is that effectively the special status of a boundary agreement as to whether or not it's a boundary agreement relies on the subjective intentions of the parties. And so that it's a remarkable type of contract in English law. I'm not seeking to challenge that, obviously, but I just observe that there's a great danger that unless this is actually properly constrained in the way that I submit under ground 2, that we have an ever-increasing peculiarity, that it produces odd results. And this is an example of how it's already quite special and doesn't merit merit extending the principle. And I do try, this is why I've tried to take it back right to the very, very beginning to see that Lord Hardwicke says it's not in rem. That it was in Halsbury's Laws of England in 1908, and then remarkably similarity to Mr. Justice McGarry's judgment, which equally is consistent with it not being in rem, and then Mr. Justice Murray rejecting my submission that it's in rem. So it's a principled argument, and it's not, and I urge you to not just simply rely just on the notion that it's an act of peace and therefore it should be given the broadest possible application, because it's, as this case proves itself, when circumstances arise where it would be deeply unfair to hold someone 10 years after they bought a property to an agreement that they didn't know of, if that is the principle, then it produces the wrong result. My learned friend in his skeleton is entirely correct to say that this is not something that we can expect to be subject to any. It doesn't touch upon the land registration scheme as it has been approved by Parliament. So it's not a sort of overriding interest or anything like that. Although I note that even that Parliament has obviously introduced certain complicated provisions for eliminating interests which are not obvious to a purchaser, and that's a topic to itself. But it has done that. But it hasn't said anything ever about boundary agreements. So that this comprehensive code, as it were, in the Land Registration Act, just simply doesn't account for this. And we have the guidance, obviously, of the Land Registry, which identifies it as an issue. So it's not an explanation in my respectful submission to say that Parliament has accepted this. And even then, I note, as I said at the beginning, that although we had Nielsen and Poole, we then have a gap with no real cases of any, no cases at all that we can find in the books until the beginning of the 21st century. But obviously this is causing problems in practice. So, my lady, the change is consistent with principle. It's not unprincipled. It's just, it's not a principle if it is proclaimed, as it were, or set out, that will cause injustice. It's very difficult to think of any circumstance where, if this principle of knowledge was applied, it would cause injustice. the only injustice that arises is in a case such as the present, because someone knows about it and they're bound by it. They can't complain. You knew, you were told. But where is the line going to be drawn? In this case, it was more than 10 years. Is it going to be 20, 30? Is it just depend upon the randomness of whether the predecessor in title or who you can call to give evidence is still alive? Whether they can be traced? Whether they can... these are questions, obviously, that relate to ground one as well, but it keeps it almost like there's a chain of knowledge where it becomes established that this is the boundary and accepted. Whereas if there's a break in that chain, a break in that knowledge, then it leads, in my submission, to injustice. So I think, unless there's any further submissions, yes, I have in the skeleton. Obviously, I mentioned that about a purchaser, an innocent purchaser, equities darling, and so on. Obviously, that's only what I'm reaching for in trying to reach for those principles, is to try and just frame something in terms of fairness. Obviously, it's not going to be. This case is not to be decided as if it was a case about beneficial interests. That's not at all what the case is about. So perhaps it's more exact to say fairness rather than inequitable, and that the common law surely should reflect basic fairness in terms of what people would expect. So ground two will reduce the fairness does tend to reduce disputes, and clarity reduces disputes. And for those reasons, entirely actually consistent with the policy of the public policy objective that has been alluded to by judges in other judgments, even by my learned friend and by my lord. In my submission, it's actually going to make things better in that regard, not worse. So, unless there's any further questions. Thank you.
No, thank you very much indeed. Mr. Adams, how long do you expect to be? I mean, not now, at 2 o'clock.
I don't know. I'm conscious of the need to fit in a brief period of reply from a learned friend. I will endeavour to complete my submissions within an hour and a half. I propose to address the questions of principle, policy and precedent, and I'll ask my learned junior, Mrs. Cross, to address the court on the final point in relation to procedure, which relates to ground two. So obviously you also leave some time for her within my time estimate. There's rather a lot to cover, but I will do my best.
I'm just trying to think about whether we need to sit before 2 o'clock, but you think that will be, we may have to sit a little later than normal, but you think that will be fine to start again at 2 o'clock?
I hope so.
Okay.
I'm fairly bad at time estimates. I, for one, don't need the full hour for lunch if it's convenient to start earlier. I'm ready to start now.
Let's start at 2 o'clock. Thank you.
All right.